Okay, great. So we're going to do Child Support 101, and we're diving into terminology stew. So we'll send out an email at the end of this webinar that has what is this called? A handout. And actually, I'll show you what it looks like if I can get my thing to stop. My goodness. There we go. It's a Word document that you can see that has all of these things on here. So don't worry, you'll get all of this. But for those of you who are new to this, if there's any words that you're just dying, but I'm hopeful that we'll cover pretty much all of these throughout. The main thing that you need to, that we'll probably start using from the get-go is DCS, is our shorthand for Division of Child Support. And we also might refer to TANF, which is Temporary Assistance to Needy Families, which is basically welfare. And then we'll go through all of the other ones. I don't think that we'll use anything else, hopefully, without explaining what it is. But feel free to call us out if we're doing that.
Because, as I said, I've worked here for 25 years, so I am heavily into the lingo. And I try to explain things, but sometimes I get carried away. So like Ilene says, if we're using lingo you don't understand, let us know.
Okay, great. Oops. Okay, yeah. So another thing about language, so we say this pretty much in every opportunity that we're talking about domestic violence and child support, that we often refer to gender of the custodial parent as female and the gender of the non-custodial parent as male. And that reflects that the majority of custodial parents in the caseload are female, and also the fact that the majority of domestic violence survivors are female. But that's in no way meant to diminish the fact that we know that there are many custodial parents who are male and many folks who are abused by their female partners. So we just want to clarify that, but as shorthand, it's an easier thing sometimes for us to refer to the genders of parties in the most typical way that we see them. Okay, so we obviously think it's important for advocates to know about child support. We're doing this webinar for you. We've been doing trainings for advocates for years about child support because we think there's just some really key components that advocates need to know in order to help survivors and their kids get what they need, but also keep them safe. So we're going to go over that fairly briefly, but in the next few slides. So what we know about child support, there's many studies that back this up, is that even when there's a small steady stream of income, so even if it's pretty small and you'd be surprised at how little it takes, families are less likely to access public benefits, and so what that means is that they're able to really make ends meet on their own. And that the other piece is that child support actually can be a pretty hefty percentage of what folks are getting in their monthly income. So that makes sense that if you aren't making a lot of money, that $200 check is a lot more meaningful to you than if maybe you have a different level of income. And so we really want folks to get what they're entitled to and what they deserve.
And one of the things that's happened in the child support world over the last few years is a desire to get what we call right-sized orders. When I first started with child support, there was sort of an unwritten goal, but a goal nonetheless, to set support as high as you could. And it doesn't always work. And so studies have shown that if I am a low-income person and I have an amount of child support that I can count on, then I can budget, then I can figure out my life, and I can set up things like childcare for my kids or whatever because I have a steady income stream. Then that is a lot better than getting me a great big payment like once a year or something like that, because I can't count on it if it's a every now and then payment. And if I'm going to reach self-sufficiency, what helps me most is a steady support obligation, even if it's not as high as I would like. And I, over the years, have met a lot of people who are not happy with the amount of child support that is set. And when we talk about it, sometimes a custodial parent will say, well, I know that I need X amount of dollars per month to raise my children, And then I ask, and when you were together with the other parent, did your family have X dollars a month? Why, no. So some people get kind of unrealistic hopes that even though they know what the income was like when the family was intact, somehow there's going to be more money in there now that they've split up. And again, studies have shown that if my child support obligation is affordable and works with my, in line with my income and my earning ability, I am more likely to pay. And again, we're looking at what's going to be best for the family, what's going to keep child support coming in.
Yeah, and I'm a parent of 2 small kids, and I love the idea of something in my life being predictable. So if we can make child support that thing that's predictable and a steady stream, we know that that's really helpful for folks. Child support can also be helpful in that it can actually cover kids with health insurance. This was something that before I started this work, I had no idea that health insurance could be attached with child support. And so that is something that if you aren't necessarily connected to that system, you may or may not know. And we'll talk about what that looks like, but that can be really helpful. And then it also can help with requiring a non-custodial parent to help contribute to a child's post-secondary education. So if folks are hoping that their kids go to college or do something after high school, if they have a child support order, they're able to ask for that. And that's the key, is that this can only happen with a court order for support. So there's some other things that you can get, but this needs to happen with a court order. So the dilemma is that we know that regular child support is super helpful to folks, especially low-income people. And we also know that access to money and resources is what often helps survivors stay safer or get safe. But we also know that going after child support can be a huge safety risk, and that there might be some implications of what that looks like. And so our hope is that we're able to give people the information that they need in order to make that decision that's best for them.
And one of my goals is always as early as possible to get the information. And so I like to especially get this knowledge to advocates who work in the DV programs, maybe even before someone comes to the DSHS office, what's going to happen. Because as most of you, I hope, are aware, as soon as I apply for TANF, I've assigned my right to child support, and I'm going to get a DCS case. And if I'm not aware of what those ramifications are, then I can be causing myself a lot of trouble. And so really the push that I'm most interested in is getting the survivor to know what the various options are, what the various dangers are before she even comes in and applies for public assistance, because by the time she applies, it may be too late unless she knows what to say.
And we really hope that by virtue of you sitting in this webinar, you'll actually have all that information that you need. So we'll go through how child support cases get opened and all of that so that you'll know how to hopefully get in front of things before things go south. So here is what the Division of Child Support can do, and here I see we have an acronym that we didn't explain. So DSHS, I'm sure most of you know what that is, but that's the Department of Social and Health Services, and they are a big, big department that controls lots of things, including child protective services, including welfare, and including child support. So the Division of Child Support is its own thing. And why don't I let you describe what you all do instead of me saying it?
Okay. The Division of Child Support is the agency in the state of Washington that maintains our child support enforcement program. We are a federally funded program, and what that means is we have a state plan that exists under the Federal Social Security Act, and it's under Title 4D. So you may hear people talking about 4D agencies. Well, that's us for the state of Washington. And the reason that the state plan is so important is we get a lot of federal funding for our program, and a very large percentage of the expenses for the child support program are funded by the federal government. We usually get a 66% match, which would mean for $1 that the state puts in, the feds put in $2. So it's a great partnership, but it's also a very controlling partnership, because in order to qualify for our funding, we have to abide by federal requirements. And every now and then we'll make a change in the program, and it's because we're required to do that by the federal government. And one of the, I guess, big things that we tend to rely on a lot is, if you don't have an approved child support program in your state, you cannot qualify for the TANF block grant. So a little later on we'll talk a legislative update, but I work on legislative issues for the Division of Child Support. Excuse me. Every now and then we need to go to the legislature and ask them to enact a law. For instance, we have a license suspension process. If you are more than 6 months behind in your child support obligation and meet certain qualifications, we can certify you to a licensing entity and ask them to suspend your license. Usually that happens with a driver's license first, but it can go on with different types of licenses. And we didn't just sit there and think, boy, wouldn't it be fun if we could suspend licenses. This is a requirement from the Social Security Act. So we went to the legislature and we said, here is our proposal, and we actually have to do this because it's required by the federal government, and if we don't do it, it can violate our state plan, which would jeopardize our federal funding, which can jeopardize the state's TANF program. And so it's kind of a big deal that our requirements, we try to maintain our best work with the federal requirements, while also looking at what is the best service we can give to the people of Washington State. And so based on our requirements, based on our public policy decisions, there are certain things we can do. If you bring us an existing child support order, we can enforce it for you. If you don't have a child support order already, we can establish one either through our administrative process, which we're going to talk about a little bit more, or through the court. And if you already have a child support order and it needs to be modified or adjusted, we can probably help you with that. And then finally, one of our big purposes, especially under federal law, is to establish paternity. And looking at the way that the laws of Washington State and other states have evolved over the years, we also can establish parentage. So we're all about, number one, finding who's responsible to support this child. Number two, making sure there's an order requiring that person or persons to support the child, and then enforcing that order. A lot of people will look at, it's kind of once DSHS enters your life, especially if you're on welfare, you feel like we've taken total control over you. But there are certain things that we won't do. One of the things that we can't do is we can't establish a spousal maintenance or alimony order. That can only happen in court. Like we mentioned earlier, through the DCS process, we can't establish post-secondary support obligations. That only happens in court. And our main focus is the support of dependent children. And we are a creature of statute. Our powers are set out in the Revised Code of Washington. And if it's not set out in our statutory powers, we can't do it. The state courts have a lot more latitude, and so they can do things like establish spousal maintenance and post-secondary support, and they can enter parenting plans or residential schedules. There's a move on that the federal government is now asking states to consider coming up with a way to get parents who don't yet have a parenting plan or residential schedule into that framework. So the concept would be, if we have a family and we're establishing an administrative child support order, is there a way that we can funnel these people into a process to get a residential schedule or a parenting plan? It's not a requirement, which is a really good thing because they're not funding us for it. But we're looking at things like, can we come up with some sort of process where, you know, you're in there to get an administrative child support order. Can we get you to the dispute resolution center or some sort of mediation to work on a plan? And then can we facilitate the entry of the order? That's all sort of up in the air. We, you know, it's in the thinking parts, I guess. And also, and the one thing we can't do is we can't enforce your parenting plan. And a lot of times people will complain from both sides. I pay support, I can't see my kid, and I have a right to see my kid. Or, you know, he's not paying support, why should he get to see the kids? And I can't remember if we talked about that, but the most important thing to think about here is they're totally separate things. I have an obligation to support my kids. I also have a right to see my kids, and those two, very often, they can't depend on each other. I remember many, many years ago having a court in King County cut off someone's what we called visitation rights back then, but he hadn't paid in over 2 years. And, you know, so normally the court is going to look at the custodial parent in this case and say, let that person see their kid. I don't care if they're paying or not. So one of the most important things, I guess, to take out of this is I can't give you a parenting plan, I can't enforce it, but I sure will enforce the child support. Do we have any questions yet? We have a little teeny question box. How can you read that, Eileen?
I know. Why can I not make it bigger? That's so crazy. The question is, oh my gosh. Hold on, can I get like, there we go. I've heard that once you establish parentage, you have a certain number of days to file for a parenting plan. Is that just when it's done through the court or also when done through DCS?
I have never heard that there's a limit on when you could do that. And sort of to look at what the process is, if you're going to enter a parenting plan, a lot of times you'll do it in the course of the dissolution, which is a fancy word we use in Washington for divorce. If we have to go to court to establish paternity, very often the court will enter a parenting plan or residential schedule in conjunction with that. And then many years ago, we instituted the acknowledgement of paternity or affidavit of paternity. And this was another bright idea by the feds, a way for unmarried parents, parents who are not married to each other, to establish paternity of the biological father. Because, you know, Eileen gave birth to 2 children, so she's legally their mother. That's kind of easy to see. But who is their dad? And so if Eileen and the father of her children were not married, one of the things they could do is sign an acknowledgement of paternity. And Eileen would sign it, and the bio dad would sign it. And if Eileen happened to be married to somebody else at the same time, there's a denial of paternity, which is what the husband signs. And then that establishes the bio dad as the father. All of that went into, we've established someone as the father, therefore I can enter a child support order. Because everything that comes into me ultimately goes into, can I get a child support order? Can I enforce it? So when we establish this acknowledgement process, then once you've established through acknowledgement, you can't bring a paternity order because paternity is already established. So the parents were sort of left there saying, then how do I get all the other stuff I would get from a paternity order, like a parenting plan? So Washington law changed, and there's a provision that says if you've already got paternity established, but for some reason you don't have a parenting plan, especially those people who came in with the acknowledgement, there's a process just to file with the court, say we already know who the dad is, we want this residential schedule, we want this parenting plan. All of that was a long way of going around to say, I've never seen that there's a deadline, and it's.
Where would we look to find out for sure? Would that be something that's available through DCS, or is that more of a? It
might be available, the information on our website, because we have information there about establishing paternity and later going there. But I will have to look it up, and I'll pass it through Eileen. Let's start by saying I am pretty sure there's no deadline, but if I'm wrong, we'll follow up with you guys. And it's sort of, you know, if I sign a paternity acknowledgement with someone, then we've established we're the parents. If we don't have a residential schedule or a parenting plan, there's no official order that says where the kid is going to reside. And if we're going to fight about it, then we may need to go to court and get the parenting plan entered. If we can work together, a lot of parents get along just fine without a parenting plan. And then something will happen. I get a new boyfriend, he gets a new girlfriend, whatever, and we start fighting. Then we really want the court order.
Yeah.
So the only thing I can think of is you have to do it before the kid turns 18.
Okay. So Sydney, hopefully we answered your question. We've got another question, and all of this, I mean, we're going to dive deeper into this, but it just, you know, every single example is such a good example of why things get tricky when there's power and control in a relationship, right? Like this thing can work really great, and it can still be really troublesome even if there isn't violence in a relationship. But we know that once there is, things get much harder, and so that's why it's so helpful to know all of this information and help people navigate it. We have one other question before we move on. It says, why is it that they require some women to file all those forms through the court rather than filing them through the DCS office?
I guess, first of all, I'm wondering, what do you mean by all those forms? There are two ways to establish a child support order. One is the administrative process. One is through the court. But I can't just go into the court and say, hi there, I'd like a child support order. I have to have an underlying action. And a lot of people, they've just separated. They're not sure that they really want to go for a divorce or a legal separation or for whatever. And if there's no court action, they can still establish a child support order through the administrative process. And
sorry, Daniela clarified that it's the child support order and residential plan that she's talking about.
I guess I'm still not clear. If you want a parenting plan or a residential schedule, you have to go to court. There is no administrative way to set it up.
I mean, I think that's the key, is that a lot of those things, even though they go together, Division of Child Support is really only responsible for the child support order piece of it, rather than the parenting plan or the residential plans. And so even though they seem linked to us, they're actually administrated by two totally different entities. The court is not necessarily connected oversight-wise. They are connected in some ways to DCS. So I think that's the tricky thing, but it's helpful. It's just helpful to have a really clear vision of where survivors are going to have to go to get their information taken care of.
Right. And sorry, and just to put you into an acronym-laden world and jurisdiction-wise, there are, families don't just stay set where they are. They move all over the country. They move all over the world. And one of the questions always comes up, which state has the authority or the jurisdiction to deal with issues? And there are different requirements and different jurisdictional rules depending on whether you're talking child support or child custody. And there's the Uniform Interstate Family Support Act, known as UIFSA, which talks about, well, once we get an order entered in Washington and the parties move away, what court has the right to make any changes? There's also the Uniform Child Custody Jurisdiction, something that begins with an E Act.
That one's in here.
That sets the rules for what court can deal with child custody issues. And very often, you'll start and you'll have a child support order entered at the same time you get custody provisions, but sometimes they don't start at the same time. And when you get into the parties moving and different actions taking place, you can have one state that has jurisdiction over child support and another state that has jurisdiction over custody. It's just sort of a mishmash of stuff. And so you don't have to learn this, but just sort of think in the back of your mind, if we're looking at modifying, changing orders, there may be different states involved
Yeah.
if the parties have moved around. And the rules for child support very often are different from the rules for custody.
Right, and that is just something, so we are really talking about Washington State here.
Yes.
So you may work with survivors who are dealing with other things, and I think that we can connect you with people who are helpful in those states, but we, it's not necessarily something that we know as well as if Nancy knows, certainly Washington law. But if you are working with somebody, do contact us if you need a connection over there, because I'm sure that we've got some people that we can help you with. Okay, let's continue. If I can advance my slide. Okay, so when does DCS get involved in your case? So Nancy sort of talked briefly about many of these in the examples she gave, but these are the ways that we know of, and certainly feel free to elaborate. But the biggest one that for me was a big aha moment was this idea of going on welfare, getting TANF, Temporary Assistance for Needy Families, automatically triggers a child support case. And that is not something, I mean, I wish we could just do like a big, I don't know, that you learn this from like the moment you're born or something, because it's not something that many people know, and so it comes out of left field when all of a sudden child support is in their lives. And so I would love it if people knew before they got on TANF that this is something that could happen. And that can be really positive, and it can also be problematic, right? So both things can be true.
And one important thing to remember is if I go on TANF with my child, that's going to be an automatic Division of Child Support case because there's an assignment of rights, and we're going to talk about the technical, what does an assignment mean. But if I get food benefits, which I grew up calling food stamps, and it's really hard for me to remember food benefits, if I get subsidized child care, a lot of public assistance benefits do not result in a DCS case. And some states will have that. There are states that say if you apply for food benefits, then you automatically get a child support case. In Washington, for a little while, we had a provision that said a condition of eligibility for subsidized child care was that you have Division of Child Support working your case. That went away, but it's likely to come back sometime.
And we have a slide on that later, so we'll talk about all of that.
And just so, right now, what's going to trigger a case is the child goes on TANF or the child goes into foster care.
And then do you want to talk about these other ones too? Sure.
And there's a requirement in Washington law that says every child support order shall provide for payment through the WSR, the Washington State Support Registry, which is a part of the Division of Child Support. We run the support registry. And every order has to provide for payment through the WSR unless the parties can convince the court that there's a good reason to provide for direct payment. And that would be, gosh, we've gotten along for 10 years and we have regular payments and we have no reason to think it's not going to help. But most orders will say pay to the registry. If you have an order that says pay directly to mom, that doesn't mean you can never get DCS services, but you need to apply for our services. And the fact that your order says pay through the registry does not mean you automatically get a DCS case. If there's no public assistance being paid and the order says dad pays mom or mom pays dad, and the way that this payment happens is through the registry, we will open what's called a payment services only case, and all we do then is we accept payments, we process them, we record them. And we will not take any action on a case unless we get an application. If you're familiar with the court order for child support, which is right now I think a 16-page form, there's a line on the very last page for the custodial parent to sign that says, I apply for DCS services. And so that is enough to get us an application in there, or someone can apply at any time after that. And either the custodial parent or the non-custodial parent can apply for services. Very often we'll get an application from a man who wants us to establish paternity, because, probably because he tried to maybe get mom to sign the acknowledgement and it didn't work, or whatever. And also, someone may apply for services in another state, and the non-custodial parent is here, so another state can ask us to open a case. But we only open them automatically for TANF or foster care.
Okay, great. So, and why don't you talk about this one too?
We have talked for a long time. There are some states that let you pick and choose among case services. DCS pretty much is you get full support enforcement services, or you get payment services only, or you get nothing. We don't have a lot of options. So like I said, payment processing is what happens if you just have a payment services only case, but if you have a full services case, we do that. We have locate services. Over the years, we've talked about, every now and then you might talk to a survivor who says, well, I'm not really worried about any danger because I'm sure no one can find him. And unfortunately, you can't rely on that anymore because we're pretty darn good at finding people. We have very extensive databases, both statewide and nationwide, and we can find more people than you think we could. We establish paternity, we establish support orders, and we can enforce medical support obligations. We'll talk about that a little more. So every now and then we would get someone who would say, I really like the fact that you do A, B, and C, but could you not do D, whatever D might be? And we can't do that. We have started calling it the full meal deal. You get all of our services or none. We don't have any midway.
So, and Nancy just alluded to this. I just want to reiterate that DCS is really good at finding people. They are excellent at this. And so even if, somebody's working under the table, there's still lots of things. If they're a hunter or they, have a driver's license, all of those things are connected. And so DCS can go in and, not allow them to renew their license. So just thinking about that, it's really hard in this day and age to fly under the radar, and DCS is excellent. They're like little problem solvers and puzzle makers, and they are really good at this. So, I just want to make sure that advocates know this, because sometimes I think things have changed a lot in the last, 10, 15 years around technology, and I think that some of us think, oh, this could never happen, but yet it can. So if the safety plan is they're not going to find him, there might need to be a different safety plan in place.
And one of the things, they call it creative ways to get an NCP to pay. Very often, if we ask the Department of Licensing to suspend a driver's license, we'll find out that license is already suspended for other reasons. If you don't pay your tickets, you can get suspended, other reasons that it would come. But there are some people who all we have to do is send the warning letter. Dear Mr. Non-Custodial Parent, your case looks like it qualifies for license suspension. Here's how to avoid it. And sometimes we just get a big check. There are other people who are never going to pay, never want to, and we'll do what we can to find them. And we also have a way to get a lien on a vehicle. And if your vehicle is worth enough, we may seize it and sell it at auction. So we try everything we can. We have a couple last resort things, which are the license suspension and property seizure. And once we've tried everything that we have in our collection of enforcement tools, we will refer the case to the prosecutor for contempt. Sometimes, again, a parent has said, no, I won't pay, no, I won't pay, no, I won't pay, and the court says, well, I find you in contempt and I'm going to put you in jail. All of a sudden, there's money.
Yeah. And so you can see how, like, for somebody who, isn't quite sure how child support will impact their ex, you could see how a seizure of a vehicle or suspending their license could really up the ante on things. And so if it was sort of questionable whether or not there'd be retaliation, that could make there be retaliation. So that's the thing I just want advocates to know, is that this is serious once DCS is involved, and that they will continue to try and find the non-custodial parent. So just keep that in mind. We have a question that says, so can DCS make a father take a paternity test?
The way that that would happen is we refer the case to the county prosecutor in the county where the mother and the child live, and the prosecutor will file an action, a paternity action in the court, and ask the court to order the parties to appear for genetic testing. And there's, if I simply ask or send a letter, dear so-and-so, please come in for genetic testing, I don't have a way to enforce that. If the court enters an order saying you will apply for, you will show up for genetic testing on this date, and the person doesn't comply, that's contempt of court. And so there's a lot of power behind that.
Somebody asks, what about if they are in or went to another county? I hear before that DCS will work with another county. Is there a list of them? Well, I think maybe what you're asking, Marianella, is there are DCS offices all across the state. There are 9 field offices, and we'll give you a list of what those are, as well as a list of some great advocates in those offices. They're called DCS, Domestic Violence Liaisons. So I have a list of those folks, and actually some of them are on the call. So hi to those DCS liaisons that are on the call. So that maybe is what you're, oh, it says country. Sorry, another country, she clarified.
It depends. My favorite answer to every question. But there are right now a lot of foreign countries with which either Washington has a direct relationship or the United States through the State Department has a relationship with. In 2007, there was a Hague Convention on, I forget the exact title, but it's on the enforcement of family support obligations in different countries. And the United States has signed the Hague Convention, but it has yet to be ratified by Congress. And one of the legislative actions from this year is we have asked the legislature to adopt an updated version of the Uniform Interstate Family Support Act to bring us into compliance with the requirements under the Hague Convention. And so when the United States becomes fully a member of the Hague Convention, and we have a non-custodial parent who went to perhaps Bosnia-Herzegovina because they're a signatory under the Hague, then we would have a way to do that. We still have some countries that refuse to cooperate, and I always think of them as the ones that won't extradite criminals. Because I know Belize is a haven. Oh, if I'm fleeing criminal charges or if I'm fleeing child support. So it all depends on where they went. And if they went because they're a member of the United States Armed Forces, that's one thing. If they just went because they wanted to live in Germany, that's another. But there are, most of the time, ways to do it. There are some countries that we just don't have any relationship with, or they don't have the legal processes to deal with child support. So every now and then you're going to get, I think we may not have any way to get someone who's in the Sudan or Libya, but things change every day. And so if you know that the non-custodial parent has left and gone somewhere, it's always worth asking us, he's gone to this place, can we get him?
Great. And we, like I said, we'll have a list of folks that are in your communities that are great allies to have, and then Nancy also is sharing her contact info at the end. So you'll have lots of folks that you can get in touch with about that. Okay, so some survivors will come in and say that they're concerned about somebody having a bad reaction to child support enforcement. So the good news is that for folks who aren't on TANF or who aren't obligated to be involved in the system, so for what we call non-assistance cases, it's up to the survivor or the custodial parent to decide if it's safe or too risky. And so if they decide it's too dangerous, she can actually just close the case. So that is the big advantage if you're not on an assistance case, that you actually do have total control over whether or not DCS works the case. That is not the most common thing, but if that's the case, then you're in luck.
And I've always been unhappy with this, that you only have one choice: keep it open and maybe it's dangerous, or close it and not get the money. We'll talk about this a little more when we talk about good cause and TANF. Is the fact that you are not enforcing the order doesn't make the order go away. So the mere fact that the survivor says, well, I don't think I'm ready to have you enforce the order today, doesn't mean that support goes away. The non-custodial parent is still going to owe it. It's just a question of when we make him pay it.
Okay, so this is what Nancy was just referring to. For folks who are on TANF, and it says Medicaid, but I don't think it should anymore.
It shouldn't say Medicaid anymore.
So the Medicaid is left over from a couple years ago when that was the case, but we'll talk about Medicaid. So ignore that. I apologize for not cleaning that up. If you're on TANF, there are ways that you can cope, and the best way is this good cause not to cooperate. So for those of you who are somewhat familiar with the TANF system, there are lots of different good cause level or things that you can apply for, and so good cause not to cooperate with DCS is the one that we're talking about. There's also a good cause not to participate, which is like if you are getting a waiver to actually not do job search or whatever else. But this one is good cause not to cooperate with child support. So the best thing as an advocate that we suggest is that to let folks know, if you know that people are going in for TANF, have them bring it up at their very first meeting if possible. And here it says don't wait for the CSD worker. CSD means Community Services Division. Those are the folks that are actually running the TANF program. And so it's kind of confusing because you go into the CSO, which is the Community Services Office.
Or you call in or you apply online.
Right. And that's where you're getting the stuff, and they're the ones that, you see handling child support, but really it's DCS folks that handle child support. So it's sort of confusing for the user because there's two different departments that are basically working on things. But anyway, if there's any way possible to bring it up at the very first meeting, that's what we would suggest. But of course, it can be claimed at any time during the time that the person is receiving assistance. Good cause is determined by Community Services Division staff, and we'll talk about how to do that. But the main thing is you want to claim good cause.
And for my purposes, I always would prefer that you have your survivors good cause not to cooperate with DCS or child support good cause, because I have found that number one, if I am a caseworker in the Community Services Division and I am working a case, my main priority is to get benefits authorized for the family. There's sort of a side thing that, oh yeah, I need to get information for the Division of Child Support. But their main goal, their main pressure is to get benefits to the family as soon as possible. And they do have a script of certain questions to ask. And I have heard anecdotally, I cannot give you an exact case reference, but someone would say they need good cause, and the worker would interpret that as work first good cause, like Ilene was saying. So this person needs to get excused from certain job search requirements or something like that. But they don't always make the connection that work first good cause and DCS good cause should be connected. So if I'm asking for work first good cause, I probably should be getting DCS good cause. So the best thing, the first thing is to talk about the DCS good cause, because if you apply for TANF today, overnight that report is going to roll and DCS is going to get this new referral tomorrow. DCS, again, federal timelines, federal requirements, we just work those cases and we open them and we start going. If you have claimed good cause not to cooperate with DCS at the time you apply for TANF, that referral comes over with an indication that there is a good cause claim pending. So DCS won't do anything. We'll wait to hear from the Community Services Division. If there is no good cause claim pending, then we're going to work the case. And, you know, surprise, we're going to start sending things out.
Right.
So very important that the survivor make it clear that we're talking DCS good cause,
Right.
child support good cause.
And just another reminder to not underestimate the efficiency of DCS. They are, I mean, they will do it fast. It's kind of unbelievable how they're very good at their job. So you definitely want to let them know not to do anything if you can.
Yeah. And DSHS has, you know, fully gone into automation and computers. And when I first started 25 years ago, we would get paper referrals. But, you know, so who knows how long those took, and if I dropped it behind my desk, it might happen. But now, you know, it's overnight and I'm going to know about it. And I think that's important knowledge to pass on.
So Joanna has a question. It says, I have learned that some survivors would file good cause not to cooperate because the abuser's family works for the DCS and the fear of breach of confidentiality. How do you guys handle those issues?
I have seen cases where it's annotated that there's a good cause issue and the perpetrator works for DSHS or works for DCS. And I have the ability to look at all of the DCS cases. I also have a professional requirement that I only look at cases for which I have a business reason to look at. If you know that the survivor has a connection, the perpetrator, the perpetrator's family, with DCS, I think that's going to need some very special attention, and I'm not sure. Because there's got to be ways to keep it confidential, and here's my prejudice showing. If I'm a perpetrator, I'm not going to worry about my professional limitations or my professional requirements. I'm going to use that to find what I can. I would say, I would hope that if you know this is there, that you would contact Ilene or contact me before the TANF application goes in, because I do have to give CSD my address. And so it may be that this is time to look at alternative addresses. We'll talk somewhere about the address confidentiality program, which works for some people but not for others. And this question has just upset me so much I can't even think about it too much.
Yeah, I mean, I think this is a case where if this is happening to you, definitely do reach out and before applying, let's figure it out.
Yeah.
I think that's the key. And, you know, the thing is that we know, of course, that's going to happen, right? I mean, survivors and perpetrators, we're everywhere in society, so there's no reason why it wouldn't happen. And I think we just have to be careful about how we handle those. So that's something that we would be happy to kind of walk somebody through or figure out what the right way to handle that is.
And I have to say, I remember a case many years ago where I think it was the perpetrator's girlfriend worked in some part of DSHS, and it was discovered that she was feeding him information. I raised a stink, and I raised a complaint all the way up to the secretary level, and I did my best to get that person fired. But, of course, personnel actions are secret. But, yeah, I want to know about stuff like this, because I will not let that happen.
And it's definitely, and it's unethical, and it's breaking some other.
And if I'm the girlfriend of the perpetrator and I'm giving him information about his survivor, then I don't have what it takes to work for the state and I need to be severely taken care of.
Okay, so in terms of how to claim good cause, so we mentioned talk to CSD staff at the time of application and as early as possible. You know, and later on too. I mean, we're saying best practice if everything, if the stars have aligned and everybody knows. It's great to do it at first, but really, in terms of what the policy says, you can apply for any time. The way to do that is that survivors will fill out a form, which is just good to, you know, they will give this to you, but it's good to know what the form is called. So again, you'll get a copy of this PowerPoint, but just to have this, you know, in case somebody needs to tell their worker what the form is. It's the 18334 form, and it's your options for child support collection while receiving TANF. And I don't know if they've changed it to take medical assistance out. It's likely that medical assistance will come back, so who knows what.
And are we giving them a hyperlink or a copy of the form?
I can. That does not look like that is hyperlinked, but I will hyperlink that. So, and basically, here's the good news. So this form used to crack me up, or actually infuriate me, to be honest, because it was, I can't remember what the title was, but it was like how you must cooperate with DCS or something, even though it was a form that was saying that you didn't have to. So it's very misleading. But we got it changed to your options. And ultimately, all that survivors need to do is they have to state their fears and concerns about what child support collection would do in terms of their fears for them or their children and their safety concerns. And so they are signing that, and it is, you know, they're signing their name to it, and so it is up to them to be truthful. But that is the requirement. There is no requirement that you need to have a protection order or that you have to have a police report or medical records. You have to sign and state that you have fears and concerns about child support collection. And it can't be, I don't want to, right? It's more, I'm concerned that X will happen to me and my kids. That is a reasonable thing to put.
Or he told me that if I ever tried to get child support, he'd kill me. Right. Very good. You know, that's a...
Right. You don't, right. And that's all you need. And so it can, you know, of course it's a formal form and it seems intimidating, but in the end you don't have to have all of this documentation or proof. But you do have to feel solid about signing your name to a statement. And that is really the key. And so some workers, you know, there's been lots of lore about this, you know, over the years of what people need, but this has been the case for a long time. If survivors are getting pushback on this, you know, I encourage you to print out the policy. I'm happy to send you that link, you know, if you're having any trouble, because ultimately they just need to sign this form.
And at the bottom of the form there are two check boxes. One says, I believe this, you know, can happen safely or something like that. And the other one says, I am afraid, I have concerns. So it's really easy to tell which one to check.
Yeah. And so when you go ahead and do this form, you also have, there's two options. And it used to be up to a worker to decide, and now it's more up to the survivor, the custodial parent, to decide. And so there's two levels. One is good cause level A. And good cause level A basically means that the case is closed immediately and that DCS will not work the case or reopen the case unless something changes, right? The beauty of good cause level A is that they won't work the case and that there's an automatic denial if somebody requests their address, if the non-custodial parent requests the address. And then if the NCP, the non-custodial parent, applies for services, they also will be denied.
And one thing that I've noticed, and something that I'm trying to expand knowledge for, is good cause level A is usually granted for like a 6-month period. And we'll get something in our case that says good cause level A granted April 11, 2015, expires October 31, 2015. And I have gotten questions like from some prosecutors' offices, well, if it expires October 31st, then I can just do what I want November 1st. And no, there is a certain review that goes on when someone has good cause level A, and they continue to receive TANF. The official DCS policy is that I don't care if that 6 months has expired. If there has not been an affirmative step, which means either the custodial parent has filed a form that says, I withdraw my good cause claim. Or if TANF has ended and she applies for non-assistance services, that case is not going to reopen. And if you ever get a question from someone about, oh, it's only approved through October, set them straight. And if you have an issue with someone who doesn't believe that, let me know. And sort of all through this is if you have problems with DSHS or prosecutors or anywhere in there, either let me know or let Ilene know, and we're going to ask you to name names, because that way we can make sure it doesn't happen again. We try to get the word out to all of our staff, and I can't tell if it's new staff or old staff who just don't like the rule, but no one has, as far as I can tell, has ever reopened the case, but I get a lot of questions on can I? And so it's firm DCS policy. If we've got good cause level A, that case is not opening again until either she withdraws the claim or until she applies for non-assistance services.
And we've had in the past, some folks have asked us questions, is this rewarding an abusive partner because they don't have to pay? And the situation is that that's actually not our biggest concern. Our biggest concern is the safety of the kids and of the survivor. And so if that's a consequence, well, that's unfortunate, but it's a better price to pay than the alternative. And so certainly we're not advocating that people don't have to, follow through with their responsibilities. And if it's the safest thing to do, I think that the state has decided that that is worth it.
And also remember that the child support obligation is going to keep adding up. If there's an existing order at the time, then we know exactly what dollar amount is piling up. And if at some time the custodial parent decides, I think it's safe and wants to reopen the case, then we're going to go and collect the whole debt.
Right, and so that means that is if somebody didn't, if they didn't apply for good cause immediately, there would be a case opened. So it's also a strategy, right? If somebody thinks that they would rather have the debt accrue over time, then that is something to consider, to having them open a case and then applying for good cause rather than applying right at the get-go.
Or it can happen that, we got divorced 2 years ago and all of a sudden now he's acting up.
Exactly.
Right. People get weird at different times.
That's true. People do get weird at different times. That's a good tag. We need a bumper sticker. The other option is good cause level B. And, I should have made this, so I had a red and green. I should have made it like an orange, because really good cause level B, I think, is more of like the yellow light, not the green light. The thing about good cause level B that I think is really helpful is that DCS continues to work the case and lets the custodial parent know what's happening, but they are not required to cooperate. And so for folks who maybe they're not sure how things are going to go, or they know that their abuser in particular is like, look, I just don't, I don't want you doing anything. And if it works for them to say, hey, I'm not doing anything, it's just the state, I can't control them. If that works for them and they don't have to participate, but it's still happening, that's totally, this is a situation where good cause level B makes sense. You get the same address protections with good cause level B, so it's helpful for folks who still think that it's safe enough to collect child support, but they don't want the NCP getting their address. So that's, I think, just something to consider. It was particularly helpful when we had pass-through to have good cause level B. We don't have that right now. We'll talk about pass-through in a moment. But it could come back, and it's a nice option for folks who don't want to cooperate and don't want to have anything to do with it, but feel like it's safe enough to have DCS go after it.
And I've talked to several custodial parents who that was enough for the abuser, when the custodial parent just said, I had to put the kids on TANF because I can't support them, and they're making this happen. I haven't told them anything. I am not cooperating. The state is doing this to you. And, again, this is, who knows what's likely to happen better than the custodial parent, because there's been the prior relationship with the abuser. And for some people, just the fact that I'm not helping them is enough to calm them down.
Yeah. So Jean has a question. She says, when a parent has avoided paying child support, can the child, once they turn 18, open a claim with DCS to claim the back child support?
No. And the reason why is Washington law and most states' law provides that current support and future support are set, and they're paid to the person who, or supposed to be paid to the person who is caring for the child. If I'm the custodial parent, I am receiving this money essentially on behalf of the child, and I'm not allowed to waive future support. A lot of times I've seen parents try to calm down the abuser by saying, well, that's okay, I won't make you pay child support. The courts will not let you do that because it's really sort of like a trust relationship for the child. But once child support becomes unpaid, it is a debt and it's owed to the person who took care of the child. So if I have a child, I have a support order, the non-custodial parent is not paying. If he doesn't pay a dime all the way through my child's minority, that debt belongs to me. And I can, if I want to make a deal with my non-custodial parent, agree to waive the back support if I haven't assigned it to the state because I received TANF, because the debt belongs to me. The future support is this amorphous thing that's coming to me kind of in trust for the kid. So the kid does not have a direct property interest in the support. And the one time that we see a case where the child is opening a case is when there's a court order for post-secondary support, and for some reason the court said pay to the child and not to the other parent.
And Nancy said something that I'm not sure that we actually addressed earlier in that, which is that if you're on assistance, that your support goes to the state, not to you. And so that is a very key thing. And so there is a big interest in the state in getting that child support because it's money that goes into their coffers, it does not go back to the parent because they've been paying for welfare or TANF payments. So that's just something to think about in terms of the seriousness of their orders and their work that they're doing. Like, they're trying to get the money back for the state. They're trying as hard as they are when they're also trying to get the money for the parent. But you understand why it kind of takes on such a big life of its own.
And so right now, if you receive TANF, you assign your right to support for yourself and anyone in the household to the state. And current law provides that you assign the support for the month in which you receive TANF. In the old days, if I came in with him owing a year's worth of support, I would also assign the back support to the state, but that changed many years ago. So I just assign a month in which I get a grant, essentially.
So Joanna's asking, how does this work when an NCP lives in another state?
If it's in another state, we're going to get them anyway. And there are different ways that we can do it under the Uniform Interstate Family Support Act, or UIFSA. We have the authority to take wage withholding action across state lines in certain circumstances. We can do that, like with a multi-state employer or something like that, or we can refer a case to the state where the non-custodial parent went, and they will do essentially what we do too.
And we have a slide on that too later. So. Okay, so this is a good question. What happens to a good question that I wrote? I'm giving myself a pat on the back. What happens to a good cause claim when TANF closes? So I'll let you talk about this because it gets a little bit wonky.
This is something that's changed over the years, and I think has changed for the better now. There's a couple different ways that this is affected. Let's say I applied for TANF and I claimed good cause, but for some reason my TANF grant closes before they make the good cause determination at CSD. These are not quick things. Normally what happens if your case comes over with good cause pending, we will tickle it to check it in 3 months. If a decision is made sooner than that, we can deal with it, but we are not allowed to really bug the Community Services Division until then. We have worked with the Community Services Division because they used to say, well, if TANF is closed, I don't have to do anything about good cause. But we want them to still make the determination, because if I claim good cause, it's going to apply to any time period. And like we said, if you receive TANF, you're assigning the rights to that support. So we need to know, even if you only received a couple months, is it safe to proceed? So we need to know if we get this good cause level A or good cause level B. And so DCS will wait for the determination. One thing that can happen, and I can't remember if it's in the slides, so I'm going to talk about it now, is if I have been receiving TANF and for some reason I want to close my case, I'm a non-assistance person now, and I've got problems with my perpetrator. If I just close my case and say, DCS, I don't want you to enforce my support, if there's still a TANF debt owing, we're still going to want to collect that. And I am pretty darn sure that a non-custodial parent is not going to care whether we're collecting money to go to the family or to go to the state. And so we have a policy that we want to, that we will warn the custodial parent, but I think you guys still need to know about it, that if a custodial parent closes the case and there's still some TANF debt, if the reason she's closing is she's afraid of the non-custodial parent, then she needs to ask us not to collect the TANF debt. And there are two ways that that can happen. One is she can request a DCS conference board, and a conference board is an in-house informal proceeding. It's not fancy like a hearing. It's not under the Administrative Procedure Act. It's a DCS sort of exception to policy type thing. And the conference board can decide that it's not safe to collect the arrears, so we'll just shut down the entire case. Or the custodial parent can make a late good cause claim. And this is something that's possible, and a lot of people don't know about it. So you can claim good cause even after TANF is closed. And sometimes you need to get Ilene or me to run interference because not every community services division person understands that. But they can make a retroactive good cause determination, and if they go back and say it's good cause level A, then we can just shut down the case and not work it again. So it's an important thing. Even if there's no current TANF, do look at whether there needs to be good cause.
Okay, great. So a denial of good cause sometimes happens, and when, you know, like anything, somebody can ask for a hearing, and so you can always ask for a fair hearing when you don't like a decision, so that's just something to know. But when there is a denial, it can be based on a couple of things. Sometimes a denial is basically just somebody withdrawing their claim. They're saying, oh, never mind, I checked the wrong box, or I didn't really mean to do that. Or there's a failure to follow up. So because we know that this can be a dangerous time, and the repercussions of this are big, there's a 90-day appeal period, and DCS actually waits that time to see what happens. And so they typically are going to wait at least 90 days after the denial to start working the case. If the custodial parent is like, wait, actually it's denied because I really just, I checked the wrong box and I really do want you to start working it, they can file a written request and ask DCS to start working the case immediately. They just have to have it in writing.
And this is because we want to make sure that the custodial parent really doesn't want good cause. And so it'll happen every now and then. And I've seen denials come out called a withdrawal, and that's just because the custodial parent didn't follow up with the CSD worker, which sure doesn't sound like a withdrawal to me. But if the custodial parent says, yeah, you know, I thought it was going to be a problem and it's not, I want you to go ahead, we will ask for something in writing, something signed by her. And again, just because it could be the perpetrator's girlfriend or somebody pretending to be, I don't know. But it's sort of a CYA act on our behalf. And we want to make sure that it's a knowing waiver, etc. So we're not trying to be difficult. We're just trying to make sure things go safely.
Yeah, and I think that really how DCS is operating here is really a better safe than sorry approach, and so we really appreciate that. I just want to check in. Yubinka, you have your hand raised. I'm going to unmute you. And I don't know if you meant to do that and if you have a question, but Yubinka, if you have a question, you can go ahead and ask it. You're unmuted. Okay, I'm going to go ahead and mute you again. If you have a question, feel free to raise your hand. Oh, wait, here we go. It was a mistake. Okay, perfect. No worries. I unraised it for you. I guess lowered it would be the word.
I like unraised.
Okay, all right, we'll move on. Okay, medical assistance only. So the next few slides are like, here's informational slides, but there's actually not actions that are different than this. So there's a couple of slides that are like, we kind of have them as placeholders because every year it's different. We never know. But at this time, if you have medical only, so if you're only getting Medicaid, it does not result in an opening of a DCS case. So the nice thing is that people who enter into that system will get a letter saying, hey, did you know that there's child support services? You're welcome to apply for them if you'd like. But they're not required. And so it's more of an opt-in rather than an opt-out situation. This has been a change. So folks who used to get medical only back before the Affordable Care Act, which is Obamacare for folks who aren't familiar with the Affordable Care Act, that is a change. It used to basically trigger a child support case, but now it doesn't. It's got too complicated. But who knows? It might change again. So I don't know if there's anything else you wanted to add about that.
I guess just to explain it, when states implemented the Affordable Care Act, they had a choice. They could use the federally based health benefit exchange, or they could build their own. And the federal health benefit exchange does have a process for claiming good cause. The state of Washington, when it built its health benefit exchange, which is known as the Washington Health Plan Finder, did not include anything that would allow someone to claim good cause. So like Eileen said, in the old days, it was if you got medical or you got TANF, we were there. And what happened with the Affordable Care Act is essentially it all used to go through the Community Services Division and then get farmed out. But now they like separated all the financial programs from the medical program. So you apply for medical a different way from how you apply for financial help. And so if I'm applying for Medicaid, there's no way for me to claim good cause. It just seemed too dangerous for us to make that go into an automatic DCS case. And we looked at a lot of different ways. Oh, we could contact the person, we could do this. And then we finally said, you know, just not going to work. So until they rebuild or reprogram the health benefit exchange in the state of Washington, we have agreed with the healthcare authority that Medicaid receipt on its own does not result in the automatic opening of a DCS case. But again, since people were trained before that if I open medical, I get a DCS case, we wanted to make sure people knew that they could apply, but they had to do it in a different step. If it's going to change, it's going to be, you know, we're waiting on the healthcare authority to do something with the benefit exchange, and we would let people know. So we're not going to do anything like, hey, tomorrow it changes.
Right.
So.
Right. We'll keep you posted about that. And similarly with child care, there have been laws in the past. You've kind of gone back and forth a few times, at least in my tenure. I don't know what it was like before me. But that if you receive child care services, there would be a requirement that you cooperate with DCS. That is not the case now. Again, there might be some misunderstanding of what the real policy of this, but what we're saying is that there is, under current law, there is no requirement. If that comes back, and similarly to the healthcare exchange, if that is something that gets implemented, there will be an option for good cause, but currently we don't need that because there is not that requirement. And there was a bill this session.
It might come back, but it's not really a budget-based bill, and now if all that they're supposed to be looking at is budget stuff, But the concept under that was, the reason I'm getting subsidized childcare is I don't have enough income in my home. Would it be possible that if I got my child support, my income would increase, and therefore either my copay might increase or I might even be over the income limit? And so it wasn't really, let's kick people off of childcare. It was, let's see what families can make it on their own, and therefore the subsidized childcare would go for the people who really need it.
Right. A lot of it is just about recouping some of the money paid out by the state.
And well, not on this, because childcare does not result in an assignment of rights. This is just money that gets paid out. So if you get subsidized childcare, you're not required to reimburse the state in any way.
Yeah, just by copay and stuff like that.
Right.
Okay. So again, this is just information for you to have. We haven't had a pass-through in the last few years, but when we did have it, it was, I think, a really helpful thing to, again, try and counter that assignment to the state, that some of the money that came through would be passed up to $100 for a family with one kid and up to $200 for a family with more than one kid.
And there is a current bill in the legislature to bring back the pass-through. It's House Bill 2220.
Okay.
2220. And looks like they're looking at the same amounts. And if it happens, it's going to be pretty darn soon. And remember that we only pass through money that we get.
Right.
And when the pass-through started back in 2008, I'd get these calls, where's my money? And, well, we didn't get any payments. So some people thought that just because the pass-through existed, they'd get automatically $100 if they had a kid. But no, we have to get a payment.
Right.
And
so if somebody's only paying $50, you're not going to get $100. You might get the 50 because it's up to that. But if they're not paying child support, you're not going to get it.
So I'm keeping a close eye on this bill.
Okay.
We'll keep Ilene advised, and
yeah, and
we'll
like I said earlier, this is another time just thinking about the pass-through and thinking about good cause level B as an option, because then there is an opportunity for folks to get more money, but without the dangerous cooperation that they have to do. So it's just something to think about.
Yeah, there's anecdotal evidence. I don't know how many real studies have gone on that if my family is on welfare and I pay child support, the money just goes to the state. If my family's on welfare and there's a pass-through, and I know that there's either, there's some of the money will be passed through the family, I might be more willing to pay my support.
Right, that makes sense.
And yeah, so it's a family-friendly thing. It's sort of a non-custodial parent-friendly thing. And what I can say is the legislature is thinking about it. I can't say it's going to happen or it's not going to happen, but we'll keep you posted.
And think about, in terms of the stats that we were talking about at the very beginning of child support making up a bigger percentage of your income, if you're on TANF, you have a family of one, your grant is, around $460. Another $100, that's a big difference, right? $560, you can do different things. And so it would make it does make an impact on people, or if they're having a grant of $540 and then they get
and the pass-through payment does not count as income against your grant. It does not count against your income for medical, but it does get counted for food stamps. And I was talking to someone a little while ago, and it was something like if you got a $100 pass-through, that would probably reduce your food benefits by $30 or something like that. So it's not a dollar for dollar, but it is a difference.
Okay. Okay, so we've talked a little bit about this, but another reminder that debt can still accrue while good cause level A has been granted. And so, again, even if you have a finding of good cause, it doesn't mean that the NCP doesn't owe the child support. So something to think about for folks who are considering lifting their good cause or considering going back and applying for services, that the NCP, the non-custodial parent, might be hit with a pretty big debt accrual order or notice or whatever it is. So, how is that going to go? So just safety planning and thinking through that option is important. So here's just some RCW links for you and WACS. RCW is the law, WACS are the regulations and how things are carried out. Sorry, I should say RCW stands for Revised Code of Washington. WAC is Washington Administrative Code. Whenever we're talking to people from other states, they just can't stop laughing that it's WAC.
Whack, whack, whack.
So anyway, so here are just some things that are helpful for you if you need to, you know, look up the actual laws and what they say.
And if you have the time, I would recommend going through Chapter 388.14a of the Washington Administrative Code. Those are all of the rules that apply to the Division of Child Support. So you'll see information on confidentiality, the good cause, what's an assignment of rights, what are the different notices that DCS serves, and what are the processes. And you know, I'm not saying you have to memorize it, but it might just
there will be a test.
Oh, there will be a test, Eileen says. We'll do that at the conference. But, you know, just sort of to get an idea of what happens.
You know, with all your spare time. Who doesn't want to read?
Yeah. Yeah, because they're so exciting. I wrote them.
But the good news, I mean, the nice thing is that there are protections available. And so this does go through in terms of that you can get notice before your address is disclosed. You can deny address disclosure. You know, it is a helpful chapter.
Yeah.
So.
And the important thing to me is when I first started with DCS, we had this notice and hearing process whenever someone asked for the other parent's address. And then based on, of course, changes in federal law, we had to change it to say the custodial parent will get notice and a right to hearing when we get a request from the non-custodial parent. But the non-custodial parent does not get that notice and a right to hearing unless he or she has asked DCS to provide notice of that. And so there's, for the people you work with, there's probably going to be some indication on the case that there are family violence or domestic violence issues. We have an indicator that we set on the person who is threatened or was the survivor that there are family violence issues. If we're reviewing the case for an address request, we look to see, are there any violence issues? And if there are, we just automatically deny.
Yeah.
And then we send a notice to the custodial parent saying, your NCP was looking for your address, but we denied. But if we don't have information that violence is an issue, then we'll start the process. So I guess we don't need restraining orders, police reports, etc. If there's no good cause on the case, I would still recommend that the survivor contact DCS and say, I have concerns about my address going out because of violence. Could you make sure it doesn't happen? And then we can update our case.
Yeah. And similarly, I know that some of you will work with folks who are non-custodial parents where they don't have custody of their kids, but they are the survivor, and you can still have them call and ask them to set the DV indicator so that their address is protected as well. All right. We're getting close here, people. This is a helpful thing that you can actually ask to use Division of Child Support headquarters mailing address on any forms regarding enforcement of health insurance. So for folks who have employer whose kids go on the NCP's employer's insurance, sometimes, you know, if the employer is, the NCP might be the employer himself, or if there's a union or whatever it is, that way they don't get that information through health insurance, and so you can use the headquarters. The tricky thing about this is that, you know, even though DCS does a great job of providing protections around their address because they can use headquarters, the insurance companies might be sending all sorts of stuff to the actual subscriber of the health insurance. And so just a heads up that that's something to think through with survivors if, like, they are taking their kid for a monthly allergy shot, you know, that could be pretty clear to the subscriber, the insurance subscriber, that that's a pattern that every month at this time they're going. If somebody is trying to stay, you know, hidden from someone, that's an issue. Or just also somebody gets to know your business, you know, what you're doing with the health insurance. And so just other things that folks who are in domestic violence relationships may be particularly nervous about, just to let them know about that. Okay, here's our UIFSA slide. We've sort of covered this. I mean, I think the main thing here is that different states operate differently, and Washington State has a really great Division of Child Support who is very concerned with confidentiality and are very good at not disclosing addresses, and other states maybe aren't quite as good. And so that's just a heads up about that, and I don't know if you want to say more about any of that.
If we have to provide the address, the actual address of the custodial parent when we refer a case to another state, we will do our best to, you know, if we have made a non-disclosure finding, we annotate the heck out of the referral and all of that. We do our best. But like Ilene said, I cannot guarantee what other states do. I did happen to give a session at an interstate child support conference last August, and I hit them really hard with this, that you have to keep it secret and you can't just send things off. And, you know, so we're doing our educational bit. Even if states aren't that hip yet to DV concerns, they at least are hearing from us.
Okay, great. So we're getting close to the end here. I'm impressed. Hopefully you all are still awake. Are there any terms on here that we didn't go? I guess we didn't talk about arrears. That's a big one. We didn't use that fancy word. We used debt. Debt, yeah.
But different places will talk about support arrears or support arrearages, but essentially it means debt. And I think one of the important things to consider around debt is any particular case may have debt owed to the custodial parent, and it may have debt owed to the state for times when support rights were assigned to the state because of the receipt of TANF. And the way that the assignment works right now is if the family is receiving TANF this month, April, and we get in a child support payment, the state will keep it. It doesn't matter the dollar amount. In the way old days with early TANF and when we were in AFDC, we had this concept called the distribution over grant. So if my grant was $400 and current support was $600 and it got paid, that extra $200 would go to me. The rules for TANF have changed, again, federal law, and the state is required to keep the entire payment. And what this looks like in reality is if in 2 consecutive months there is more collected in current child support than is paid out in a grant, then the grant gets automatically terminated for the 3rd month. And so we hope that the reason it's terminated is that we're now getting a regular source of payments. But every now and then it can happen that we get 2 good months, TANF is terminated, then he quits his job or something bad happens, and so there might be an on and off TANF result. But the TANF rules say if you get more than current support for 2 consecutive months, in the 3rd month you're going to terminate the TANF grant.
And it looks like the other one that we didn't really use but is a helpful one is SEO, which is Support Enforcement Officer, which are friendly DCS workers. Those are just folks hopefully that you know in your community but who do all the great work at child support. So if there's another one that you want us to cover, feel free to write in the question box or raise your hand. So are there any other, ooh, I didn't realize, look at that. I didn't realize it was actually moving. It's so exciting. Wow, it's fancier than I realized.
I'm getting seasick.
Are there any other, oh, here we go. Annual fee for what? Oh, we didn't cover that one.
Oh, we did sort of forget to talk about the annual fee because our focus is so much on TANF. But under, again, federal law, states are required to collect an annual fee of $25 if there are at least 500 more than $500, a federal fiscal year starts out geared at non-assistance cases. And so if you think, like, if I have a $25 a month order, that's only $300 a year, so I'm not going to hit the requirement for annual fee. But essentially what happens is we go through to the family, and then dollars 501 through 526 are kept by the state for the annual fee, sent on to the federal government. You are not required to pay an annual fee if you have previously received AFDC, TANF, or tribal TANF. And most of the time our case will show that information, but every now and then we'll hear from a parent who may have the annual fee, but the annual fee will get waived. You just need to bring that to our attention.
Great. Other questions or comments? Oh, it looks like Lana, you have raised your hand, so we can hear you.
Okay, so I just wanted to say this is probably one of the best presentations I have seen in a long time through the webinar.
Thank you. We love validation. Thank you.
Very, very clear, very explicit. I'm actually a domestic violence counselor down in Kent, and this is so helpful to me when dealing with both my clients as well as the victims. So I did not know a lot about child support and how it all worked, and knew something.
Our day is complete. Okay, yeah, we can go home after this.
Yeah.
Thank you.
Yes, very, very good. Thank you so much. And I look forward to seeing you on May 5th.
Oh, perfect. Okay, great. Thank you.
Thank you.
All right, that's it? No question? Oh,
Yeah,
even better.
no,
Thanks, Lana.
no question. Just a very big thank you for a good presentation.
Oh, good. Thanks. Okay, we've got another question here. So about when the NCP is in another state, what is the average time it takes to find an NCP? Oh, that's probably very varied.
Here's my favorite answer. It depends. And, I'm just going to say if your non-custodial parent is in a state that has an amazingly wonderful child support program, not that long. If it goes to a state that's not that sophisticated, it might take longer. But I guess the only thing I can say is we don't give up that easily, and people will keep looking. And then we also have a question.
Oh, yeah, so Jim Ward, who is one of our one of our friendly DCS DV liaisons, thanks for this, asked, was the ACP mentioned or explained? So, we didn't take our time to really explain it because I know that most of you who are advocates know what the ACP is, but the Address Confidentiality Program. But the thing that we didn't say that we should say, then I wrote myself a note to make a slide for next time, is that DCS and CSD, the welfare side of things, that they will accept the ACP address, that they don't need to actually get your physical address. And so, again, there might be some misunderstandings out in the field on whether or not people are following their policy, which says to accept the ACP address. If you need any help with that, I'll make something that says where that policy is. But the main thing is if folks are involved in that program, they can use that address as their address for all benefits.
And then just to add a point here, if your survivor happens to be a non-custodial parent, by signing up with the Address Confidentiality Program through the State Auditor's Office, is that where it is?
Secretary of State.
Secretary of State, sorry. When I sign up to be a participant in the ACP, I authorized the Secretary of State to be my agent for service of process. And so that means if DCS is sending out notices and we send them certified mail to the ACP address, that constitutes good service because the ACP participant has authorized the Secretary of State to accept documents. And so it happens that we mail things out. And again, one thing that I didn't get a chance to say is when you're working with survivors, it's hard to cope, it's hard to deal with things, but please remind them to open documents that they get from DSHS because they could be things that they don't want to happen, Could be a notice saying that their good cause claim wasn't approved. could be something else. And so it's hard to, deal with those details when you're struggling to keep yourself and your kids alive and fed and housed. But I guess not every letter from DSHS is good news, but almost every bad news from DSHS you can appeal. So.
Yeah, that's true. And it is, I mean, it is really helpful. I think one of the best things that advocates can do is offer to help read the letters together, because it is really confusing. Because for me, it's hard for me when I get something and the first thing is if you want to appeal, like you have to kind of flip through the pages of like, what am I wanting to appeal? And it often starts with, if you want to appeal, here's how you do that, but you don't even know what the decision is. So it can be sort of overwhelming. So that can be a really helpful advocacy technique, is to just say, hey, let's come on your next appointment, bring your letters, and let's read through them together. But yes, it is helpful for folks to open their mail. I mean, I am terrible at opening my mail, so I totally get.
And one thing that I noticed years ago, we would get hearings on distribution notices. When payments are made on a case, DCS sends out a notice to the custodial parent showing this is the money that came in, this is how we applied it. And then there's a block which says, if you want to object to this, sign here and mail it back. And I would get a case for a distribution hearing, and I talk to the custodial parent, and I say, well, what's your problem with distribution? He says, I don't know, it said sign my name and send it back. So I did.
Yeah.
And again, I think Ilene's suggestion on helping people read through the confusing forms is good. We do our best to make them not confusing, but there's so much stuff that we need to get in there that
it's gotten better over the years. Yeah.
And I guess one thing that I want to remind people about the address confidentiality program, when I first started with DCS, we had a brochure, and it was the best thing since sliced bread, and you handed it out to everybody. Now I can't apply directly. I have to go through an advocate. And the most important thing is I have to be moving. I have to be changing where I am. And I think one of the best examples is me. I bought my home in 1998. So I'm on record as a property owner. I have bazillions of things available on the internet. If I just go to the ACP and say I need an official substitute mailing address, they're not going to accept me because everybody in the world knows where I am already. But if I'm saying, okay, I have all this stuff for me on record, now I'm going to a new place, that is how the ACP can help me. And the question has come up a few times, can someone from another state be part of our ACP? And the answer is no. And so I guess one thing to consider is, if my perpetrator knows I'm in Washington, is that enough information for him to know where I am? And, again, other safety planning stuff that we really can't. There was a horrible case, and the woman was in Montana, and Secretary of State said, gosh, we're really sorry, but we can't do that because one of the requirements is you reside in Washington.
Okay, and if you need more, I'm always happy to answer questions about that. I think most of you hopefully are connected with folks at your programs who are probably more of experts on that than I am. But we did just get another question. How would you proceed on finding an NCP that is currently undocumented and the CP is requesting child support for U.S. born children?
We rely on any information the custodial parent can give us. What I've seen happen a lot is undocumented parents very often will work using their children's social security numbers, so we can at least get some sort of a fix. And again, the further off the grid you are, the harder it is for us to find you. I'm a state employee. I've worked for the state for 25 years. I am very easy to find. I'm also very easy to set a child support obligation for because I am a salaried employee and I don't have any other income. Contrast that with, the guy who's a shade tree mechanic and works for his contractor buddy who never reports him and lives in a truck and parks it in different friends. It's different cases take different things. And very often what I found, especially with people who don't have a big earnings history, is we can talk to the survivor and say, okay, just tell us about your life. You know, what did you guys spend when you were together? What was there? And so it's hard to come to a support amount. And then again, it's hard to find someone. And we hope with someone who's really under the table that maybe we can get him through license suspension. Maybe we could get him through his vehicles. And one thing to remember is a child support order is collectible until 10 years after the 18th birthday of the youngest child named in the order, which is a whole bunch of gobbledygook. But if you have an order with 2 kids, that order is collectible until the youngest child is 28. And sometimes we just need to wait for the other parent to grow up and become a regular member of society. And I've seen a lot of guys just, you know, do their best to hide till their kids are 18, and then they think, oh, I'm safe. And they'll go out and they'll join the documented world. And then we find them.
All right, I'm going to move on, but that doesn't mean that there isn't more opportunities for questions. Oops. Hold on, I think there was a previous one. Oh, no, that's it. So this is my cute slide of Schoolhouse Rock Bill.
I have a little plastic statue of Bill, and there was a little bit of frivolity going around in the office, and he fell on the ground and broke.
Oh, no.
And he's a rubber stamp, and his stamp says, there ought to be a law.
That's cute. Well, is there anything, you've talked about a few things, is there anything else that you wanted to update us on?
I would say keep an eye on House Bill 2220. Again, Section 1 talks about bringing back the pass-through. Section 2 creates a $75 income disregard for TANF purposes. I'm not a TANF person, so I'm not exactly sure what that means, but it will hopefully result in less income to be counted against the grant for eligibility purposes. The regular legislative session is scheduled to end Sunday, April 26th. Today is the 21st. The last time I looked, there was not a state budget. The governor has the authority under the state constitution to call the legislators back for one or more special sessions. And I would not be surprised if we had at least one special session. I call your attention to 2013, another budget year, where we didn't have a budget until June 26th. We went through all sorts of horrible things in the department because we had to plan on how to keep state government going if we didn't have any money after June 30th. And what did we have to do with federal requirements, et cetera, et cetera. So I'm hoping we don't have to go through that all again this year. I haven't heard anything definite about whether we'll go to special session or not, but I am sort of hoping in a way that we do. And the reason for that is there was a bill, House Bill 1037, which they've been trying for years to adopt the recommendations of the 2011 Child Support Schedule Work Group. And if a special session is called, any bills that died during the regular session can be resurrected. And if they finally do pass House Bill 1037, there would be some changes to the Washington State Child Support Schedule. So it would give me things to talk about at the WSCDIV annual conference. But I don't know what's going to happen with that.
Yeah, and there's other bills that have died that we don't want to come back.
Right.
So it's hard.
Yeah. It's a hard thing to think about. One thing that may be relevant to you, there's a bill 1282, which clarifies that if I get arrested for driving while license suspended and my license was suspended for child support noncompliance, that I should be charged with third degree, which is you're suspended until you do whatever they want you to do. There was some concern that some courts and some counties have read the driving while suspended statute to think that you had to charge me with second degree, which is a mandatory 1-year suspension. And so we've been working, saying the purpose of license suspension for child support is a coercive one. And once you start complying, then we want you to have your license back. We don't think it should just be, because punitive, a 1-year suspension, that does me no good.
Right, and it might actually prevent you from getting child support if you can't work.
Right.
Yeah.
And then what happened as a result is there were a couple of counties then that wouldn't charge driving while suspended because their courts wouldn't accept if it was a driving while suspended too. So that, just a little minor tweak, but not a lot passed that I know about.
Yeah. Okay. Here is Nancy's contact info. Like I said earlier, we will send you this out, so you don't need to furiously write it down. But it's so helpful that you offer yourself up to us. We just so appreciate it. On another note, here is a list of all of your local DV liaisons. There's sometimes there's more than one in an office, but these folks are just great. I know Jim was on. I'm not sure if other folks have been on, but they are just tremendous resources who understand domestic violence and understand child support and understand like the ins and outs of child support and how most of them are all support enforcement officers themselves, and they're working cases and can get involved when domestic violence is present and somebody needs some assistance in their office. They're also really great community resources for us. So thank you to them. They are tremendous. We love them. And if you want to get connected to them, feel free. They are always happy to hear from advocates.
And I love the little panda baby.
I know, how cute. And then here's just some reminders. We have lots of trainings. I was going to put them up, but then I realized we have a lot happening, so I just sent you the link for our current calendar. Somebody mentioned that there's a May training that's about advocacy with Jill Davies, who is just an amazing author, advocate, ally, great lawyer, everything. And she's coming May 5th to the west side and May 7th to the east side. The information's on our calendar, and she's going to be talking about advocacy that is better for both advocates and for survivors. So kind of an approach to that. There's also our Goodwill Refuse to Abuse 5K. This is a fun event. There's not a lot of deep thinking here, which is always good. But we need runners, walkers, and volunteers, and you can find all that info out at this website, refusetoabuse5k.org. So that is very exciting. And then Nancy's been mentioning we have our annual conference this year. It's in Spokane. It's at the end of September. Our theme is We Belong Together, and it'll be a lot about intersecting allied social justice movements and other allies in the work and how we can all do this work together. Nancy and I will be doing another show. If you just can't get enough, you're welcome to come to our workshop there, but also encourage your colleagues to come so all of us can kind of get on the same page.
And will we once again have the LEFA bookstore?
Every year we have LEFA bookstore, so hopefully, I haven't heard that she's not coming. And then we have a lot of these resources are on our Economic Justice Project page on our website. Again, just a reminder, I really want to hear from you about how this was for you and what you'd like to see next time. And then also it asks about your attendance, so who else was listening at your computer with you.
Do you take attendance and people get credit for this?
They do. They can, yeah, so we send people, they can get 2 hours for this webinar, and then they can use it for their continuing education requirements.
So we're not just asking you for names for fun. There is a reason.
Right. I mean, it's up to them if they need to be sending that, keeping track of that or not. Somebody asked again if we will be sending out this PowerPoint. Absolutely. There'll be the PowerPoint and the terminology Stu handout we will send out shortly after this webinar. And I think that is it. You have we've gifted you 4 minutes for your life that maybe you didn't think you were going to have. It's 11:56. Thank you all so much. Great conversation, great questions. Really appreciate you participating. I know sometimes it's hard on a webinar to stay connected, but we just appreciate you all hanging in there with us. And I just want to say thank you again to Nancy. It's always a pleasure doing a webinar adventure with you, and we just appreciate your partnership so much.
And thank you all for being there and for what you do.
All right. Take good care, everybody. Bye.